Good evening, friends. Welcome to this webinar organized by BCSC. Before we proceed, I request all of us to rise for a motto.
येष सुप्तेषु जागृति येष सुप्तेषु जागृति कामं 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 कामंशो पुरुषो निर्मिमाणः तदेव शुभ्रं तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शितः सर्वे तदूनात्यपि कश्चन एतद्द्वैता
Sir, good evening, everyone. I welcome Company Secretary CS DIVESH GOYAL. Also, before, sir, let me apologize and also appreciate because we had to reschedule this particular meeting 3 times, and every time you always accommodate us, and thanks a lot for joining us. I also appreciate as well as thank to CA Krishna Kumar, convener of JB Study Circle, who has introduced CS DIVESH to our study circle and recommended his name. CS DIVESH GOYAL ji is going to address us on recent amendments in CARO Schedule 3, and if then time permits, he will take up adjudications, penalties, etc. Now I request CA Lalit Panchal to formally introduce the speaker. Thank you.
Thank you, sir. Thanks for this opportunity to introduce the learned speaker, CS DIVESH GOYAL ji. He is a fellow member of the Institute of Company Secretaries of India, having intense expertise in corporate law for the last 8 years. He is young and progressive practicing company secretary with zeal to dig deep into the nuances of corporate laws. Being a researcher at heart, he has done meticulous research and has penned various articles on the Companies Act 2013 to keep at pace with the latest changes and critically dissect the implications of various provisions of the new act. He has co-authored the company law premier book published by the Institute of Company Secretaries of India. He has also added a lot to the issuance of various guidance notes by ICSI. He was a member of the Task Force Committee and Research Committee for 3 years. He is a member of various committees of the NIRC of ICSI. His articles have been published in ICSI magazines and are available on various popular websites relating to corporate law. He has deliberated at several forums on corporate law throughout the country. Over the last 2 years, he has deliberated more than 150 seminars and penned approximately 700 articles on multiple topics of corporate laws. With this wonderful introduction, sir, please accept this e-memento from Borivali Central City Study Center. You are welcome, sir, and you may start your session, please. Sir, you are on mute.
Yeah, thank you so much, Aliji, for this momentum and my brief introduction. And thank you, Sharad sir, also for his words of wisdom. So thank you so much, Borivali chapter and Nilesh ji, first for giving me an opportunity to interact with the member of the Borivali Study Circle. as we know, because of the COVID, lot of things has been changed. But the best part of the COVID, which we can take all these webinars. Because before this webinar, we was doing all the physical programs and all. For that, we have to travel for so many places. But I must say, which I feel, because in last 2 years of the COVID, 2020 to till now, almost 200 webinars I have done throughout the country. The best part is that from the one place, we can interact with the member throughout the country. So I must say, this is the beauty of the webinars. And thank you so much for all of you. Because of efforts of all the study circles and you people, everyone is getting benefited from this. So sir, really, you guys are really doing a great job, because मेरा पीछे नीलेश जी से भी discussion हो रहा था काफी. So on the regular basis, you have doing so much of activities, and practically these are all for the members only. So that's the great thing we can do as a professional for the profession. Because my only thought, because we are the professionals, everyone should work for the profession. On the same line, on the same thing, I'm also going on since long time. So now today the topic which is assigned to me is relating to the amendment under Schedule 3 and CARO. We know under Companies Act on the regular basis, lot of amendments came. On regular basis, these are going on. Practically, there is no, we can say there is no one can say how many amendments came in the last 4 years, last 5 years. So almost 7 years has been completed to this act. And since still, see, every month we are seeing lot of amendments. Abhi bhi amendments ruke nahi hai, they are continuing going on. Even last year was the COVID year, 2021. Still, almost 70 notification has passed by the ministry in last year. A lot of things we can say still in their pipeline, which they want to implement in the coming time on the Companies Act. So recently, the biggest amendment which they have done from the point of view of the corporate, from the point of view of the chartered accountant, they have done the so many amendment in the, we can say, financial statements, disclosure in the financial statement, disclosure in the CARO. Definitely due to this COVID, they was just deferring it. Okay, so next year it will applicable next year. Because earlier the CARO, they was about to applicable under 2019-20. But then they deferred to 2020-21, and now they defer to 2021-22. Okay, 2021-20. So this year when will end, we have to use a new CARO. We have to go for the disclosures as per the new amendments. So because of COVID, उन्होंने काफी we can say कि काफी defer किया है amendments को, और we can say कि amendments के effect को भी. But now we are in the end of January. I can say this is a high time for this thing, because February or March only are 2 months are there. After that, we will start working on the financials of the 31st March 2022. So when we will start working on the financials of the 2022, lot of new things we have to do. Generally in my seminar, I say one thing on this, कि अगर हमें एक बैलेंस शीट को प्रिपेयर करवाने में, एज अ प्रोफेशनल एक बैलेंस शीट को प्रिपेयर करने में अगर उस कंपनी की 5 या 10 आवर्स लग रहे थे, तो अब उसको हमें 20 आवर्स देना पड़ेगा. मतलब फर्स्ट ईयर ऑफ अमेंडमेंट वैसे भी हमेशा एक ज्यादा होता है, बिकॉज फर्स्ट ईयर में लॉट ऑफ थिंग्स वी हैव टू डू. नेक्स्ट ईयर तक क्या होता है कि एक सीक्वेंस बन चुका होता है, एक प्रैक्टिस शुरू हो जाती है, एसओपीज बन जाती है. But first year we have to prepare the SOPs. First year we have to prepare the processes of that. So the first year of amendment is the most important year, because first year lot of things we have to do. And one more thing, as we know, as I'm going to discuss about the amendment in Schedule 3, amendment in the form of addition of the disclosure in Schedule 3. So the what will be happen actually, like if we have to prepare the disclosure of Schedule 3 for the 31st March 2022. The same thing I have to prepare for the 31st March 2021 also. Sorry. As we know ना, because क्या बैलेंस शीट हमें जो बनानी है वो 2 years की बनानी पड़ती है. अब जो हम 31st March 2022 we will prepare, for that we have to prepare for the 31st March 2021 also. So whatever new disclosure we will give in 31st March 2021. Same new disclosure we also have to give in the 31st March 2022 and 21. So both the years. So amendments का जो financial statements के amendment है, what we can see the increase in the disclosure of the financial statement. The major impact of that कि we have to spend more man hours for the preparation of the financial statement this year. Because earlier we were spending the time, definitely already we have spent lot of time. But now there are the many new things are there. So much more time we have to spend this year for preparation of the financial statement. So I think just my suggestion to everyone that this year you have to plan accordingly for the preparation of the financial statement. Because amendment they have made in the auditor report, amendment they have made in the CARO, amendment they have made in the Schedule 3. But I must say, according to my understanding and according to my experience, the amendment which they have made in the financial statement, they are very big amendment, and that gonna take a lot of our time for preparation of the financial statement. So let's not take much time of everyone, and let me start for the discussion of the amendment in Schedule 3 along with the other amendments. One more thing I just request to everyone, whatever queries came into your mind during this session, whatever is the queries, please feel free to ask your queries in the chat box, in the question answer box, because the purpose of these webinars, the purpose these study circles are organizing the webinars to get the clarity on the provision. So we should get the clarity on the provisions. Provisions पे clarity होना mandatory है.
Sir, आप mute हो गए.
Yeah, sorry. So the main thing, we should get the clarity on the provision. That is very important for the professionals. So now let's start with the discussions on the amendment. And again, I'm saying, please try to ask whatever queries you are having in the chat box, in the comment box, in the question answer box. So we will try to solve all the queries simultaneously during the session. Because sometimes what happens, we are discussing a point. उस पॉइंट से रिलेटेड क्वेश्चन अगर उसी टाइम हम डिस्कस कर लेते हैं, क्लियर कर लेते हैं, दैट गिव मच क्लैरिटी देन इफ वी टेक एट द एंड ऑफ द सेशन. बट व्हाटएवर द क्वेश्चन विल बी देयर, वी विल ट्राई टू टेक इन अ मैनर की सम क्वेश्चन ऑल टुगेदर, सम क्वेश्चन एट द एंड ऑफ द सेशन. सो लेट्स स्टार्ट विद द डिस्कशन ऑन दैट. So on 24th March 2021, however, almost 9 months has been spent, 9 months has been passed to this amendment. But this is a crucial amendment. These are the new amendment because अभी तक इन amendments को effect हमने use नहीं किया है. They came on the 24th March 2021 to amend the Schedule 3 Companies Act, that with the Companies Rule and Companies Audit and Auditor Rules. So 24th March को suddenly Ministry have issued some notification and they have amended the rules. So they have amended 3 rules. One, rules relating to the Schedule 3. Second, they have amended the Companies Account Rules 2014. And third, they have amended the Companies Audit and Auditors Rule 2021. So on the same day, 3 rules has been amended by them. And I will say all these three are the very important rules. One is relating to the Schedule 3. Our all practical working, everything is relating, our financial statement is complete. What is that? That is Schedule 3 disclosures. Account rules. Accounts rules are also important because it's include the financial statement, it include the board report, then audit and auditors rules. Audit and auditors rules so definitely are important for us, but whenever we are doing the statutory audit, we have to follow these rules. So on 24th March 2021, they came with the amendment in these 3 rules. Because of these 3 rules, what they have actually done, they have enhanced the disclosure requirements. जो ये amendments आए, ये 3 जो notification आए 24th March 2021, the main purpose, the major focus of these 3 notification, we can say, enhance the disclosure requirement of the company. Disclosure requirement in financial statements, disclosure requirements in director report, and disclosure requirements in auditor report. So because of these 3 notification, disclosure requirement in these 3, we can say in these 3 important documents has been increased in manifold, which we will discuss one by one in this webinar. Financial statement, one of the most important document of the company. Board report, audit report are also the part of the annual report and also the very important document. So by just one day, they have made amendment in these 3 documents. And practically what they said earlier, the day they issued this notification, they said these notification going to effect on the immediate date, going to implement on the immediate date. So according to them, they were implementing these amendments from that day only, from 24th March 2021. But later they pass a notification, we can say a clarification that these amendments, these disclosure will be impact from the 1st April 2021. So they said that this will be applicable on the 1st April 2021, means the financial statement which we will prepare for the 1st April 2021 to 31st March 2022. On those financial statement, all these amendment will be we can say all these amendment will be implemented on those financial statement, on all those documents. अब क्वेश्चन आता है, सबसे इम्पोर्टेंट क्वेश्चन, बिकॉज जब ये अमेंडमेंट भी आया था ना 24 मार्च को, that time also I have taken some webinars. So one question was coming from all the professionals, whether in the webinars, whether through the social media, कि why these amendments are coming, what are the purpose, practically purpose क्या इन amendments का लाने का. तो I must say the first purpose of this amendment increase the stringency in the compliances, because disclosures increase कर दी हैं, so compliance now will be more stringent because more information we have to give, addition of the numerous disclosure, and the most important thing to more transparency. We know the financial statement, board report, and auditor report of the companies are available on the MCA website. You want to see the balance sheet, director report, auditor report, so the any company is available on the MCA website. Now, when we will give the more disclosure in the financial statement and publish this financial statement, board report, auditor report on the MCA website, then we can say transparency will also increase. So, जो major focus of government का ये disclosures increase करने से, stringent करने से, that is transparency. So, main जो purpose है, even we know ना, whenever there any amendment came, along with the amendment, report also came. That is we call the company law committee report. So, in the company law committee report specifically, they have mentioned that the major reason why we are coming with this amendment is the transparency in the provision of the corporate law, transparency in the document. Because as we know, as on date, government are working on the Make in India, ease of doing business, more transparency, more transparency. So this is one of the move in the form of transparency. So this is just a brief table I have given. On the 24th March 2021, these three notifications came. First, Companies Audit and Auditors Rule 2021, which is impacting our auditor report. Companies Account and Amendment Rules, which is impacting our Directors Report, and Amendment to Schedule 3 to the Companies Act, which is impacting our financial statement. So practically these three amendments came on the same day, and it was mentioned in the clarification letter, all the amendment in these three rules is gonna impact from the 1st April 2021. So as mentioned, above mentioned amendment shall came into force from the 1st April 2021. Earlier there was the difficulty when this came, but now they later on they clarified that. So let me discuss one by one the amendment. First, we will discuss a small amendment which is related to the Companies Account Amendment Rules. Because of the Companies Account Amendment Rules 2021, they have, we can say, amend the provision relating to the Director Report. It is not a big provision, that's why I just added this also in our today's presentation. Because once we are discussing about the Schedule 3, CARO, Auditor Report, we should discuss about these amendments also, which are very small amendments. So the first amendment they made in Rule 3, manner of book of account to be kept in the electronic mode. See, this is a very important thing. Manner of book of account to be kept in the electronic mode. Because क्या है? There is a Rule 3 under Companies Account Rules. वो Rule 3 बोलता है, जो अभी तक rule था till date, till 24th March rule क्या था? The books of account and other relevant books and papers maintained in the electronic mode shall remain accessible in India so as to be usable for subsequent reference. This was the provision. So according to this provision, ये provision 2014 से है Companies Act में. Since 2014, this provision is there under Companies Act, and according to this provision, sorry, the books of account and the relevant books of paper company can maintain in the electronic mode. अभी तक हम मेंटेन करते भी थे, हम different सॉफ्टवेयर यूज करते हैं अकाउंट्स प्रिपरेशन के लिए, तो हम उसे इलेक्ट्रॉनिक मोड में मेंटेन कर रहे हैं. तो many things we are doing, but now they have added new provision. This is a very important point. Provided that for the financial year commencing on or after 1st day of April 2021. Now we will read this as a 2022 because only for this specific provision they have replaced this 2021 as a 2022. जस्ट फॉर द अंडरस्टैंडिंग, जस्ट फॉर द नॉलेज पर्पज मैंने यहाँ 2021 लिखा था, बट ये आज की डेट में 1 अप्रैल 2022 है। फॉर द फाइनेंशियल ईयर कमेंसिंग ऑन और आफ्टर 1 अप्रैल 2022, every company which uses accounting software to maintaining its books of account. You all are the chartered accountant. I can see almost 190% is there. You all are using the different software on the everyday basis for preparation of the books and accounts. आज की डेट में 99.99% कंपनीज अपने बुक्स ऑफ अकाउंटिंग सॉफ्टवेयर के थ्रू ही मेंटेन कर रहे हैं, चाहे वो टैली हो, बिजी हो या कोई और स्पेसिफिक सॉफ्टवेयर हो। तो जो ये लाइन लिखी है, एवरी कंपनी विच यूजेस अकाउंटिंग सॉफ्टवेयर फॉर मेंटेनिंग ऑफ अकाउंट, तो प्रैक्टिकली एवरी कंपनी में सभी इंक्लूड हो रही है। शैल यूज ओनली सच अकाउंटिंग सॉफ्टवेयर विच हैविंग फीचर्स ऑफ, मतलब अभी इन्होंने एक प्रोविजो ऐड किया है रूल 3 में कि कंपनीज वही वाला अकाउंटिंग सॉफ्टवेयर यूज करेगी जिसमें बिलो मेंशन फीचर्स होंगे। फीचर नंबर 1, रिकॉर्डिंग ऑडिट ट्रेल ऑफ ईच एंड एवरी ट्रांजैक्शन। Can anyone let me know what is audit trail? You can answer in the chat box. अभी तक 2013 से 1956 में ऐसा कोई प्रोविजन नहीं था। Now they came up recording audit trail of each and every transaction. What is audit trail? तो मैंने यहाँ पे definition mention किया है। Audit trail means an audit trail is defined as step-by-step sequential record. Please focus on the words because ये बहुत important provisions हैं। Step-by-step sequential record which provide evidence of the document history of financial transaction to its source. An auditor can trace every step of the financial data of particular transaction right from the general ledger to its source document with the help of audit trail. So मिनिस्ट्री ने मेंशन किया 1 अप्रैल 22 से, मतलब अभी हम हैं जनवरी 22 में, तो नेक्स्ट 2 months more, 1 अप्रैल 22 से every company which is using the accounting software, तो every company में 99.9% companies इंडिया में accounting software यूज कर रही है, they have to make sure कि उनके सॉफ्टवेयर में audit trail का फीचर होना चाहिए। अगर audit trail का फीचर नहीं है तो they cannot use that software for the purpose of using of the books of maintenance of books of account. Practically क्या है, मैंने कुछ सॉफ्टवेयर देखे हैं जिनमें audit trail का फीचर अभी भी है, बट अभी उनमें क्या है कि नो का ऑप्शन भी होता है कि you want to on the audit trail, you want to don't want to on the audit trail, तो प्रैक्टिकली सब नो करके रखते हैं। बट 1 अप्रैल 22 से ऑडिट ट्रेल मैंडेटरी है। आप जो भी सॉफ्टवेयर यूज करते हो, आप अपने ऑफिस में यूज करते हो, आप अपने क्लाइंट प्लेसेस पे यूज करते हो, तो आपको ऑडिट ट्रेल वाला ही सॉफ्टवेयर यूज करना है। आपको ये चीज अपने कलीग्स को भी अंडरस्टैंड करवानी पड़ेगी, क्लाइंट्स को भी अंडरस्टैंड करवानी पड़ेगी। सेकंड, 1 फीचर ऑडिट ट्रेल होना चाहिए। सेकंड, creating an edit log for each change made in the books of account. हम टैली में सॉफ्टवेयर, हम एग्जांपल लेते हैं टैली से, कोई एंट्री करते हैं, फिर उसमें हम कुछ चेंज कर देते हैं। मान लो कोई डाटा डिलीट कर दिया, ऐड कर दिया, रिप्लेस कर दिया, सब्स्टिट्यूट कर दिया, तो एक एडिट लॉग बन जाएगा कि आपने पहली एंट्री क्या की थी, क्या चेंज किया है, क्या डिलीट किया है, क्या एड ऑन किया है, एक प्रॉपर ऑडिट लॉग बन जाएगा। डेट व्हेन सच चेंजेस इज मेड, जिस दिन वो चेंजेस किए होंगे उस दिन की डेट्स के साथ एक एडिट लॉग बनेगा। एंड यू हैव टू मेक श्योर कि आपके सॉफ्टवेयर में ऑडिट ट्रेल को डिसेबल करने का ऑप्शन नहीं होना चाहिए। सो दिस इज गोइंग टू बी रेवोल्यूशन इन द अकाउंटिंग सॉफ्टवेयर हिस्ट्री, बिकॉज अभी तक हम कोई भी अकाउंटिंग सॉफ्टवेयर यूज करते थे, उनमें कोई हमें स्पेसिफिक रिक्वायरमेंट्स नहीं थी। हमारी पर्सनल रिक्वायरमेंट्स कुछ थी तो डिफरेंट थिंग है, बट गवर्नमेंट की कोई स्पेसिफिक रिक्वायरमेंट नहीं थी कि अगर आप अपने अकाउंट्स इलेक्ट्रॉनिक मोड में मेंटेन कर रहे हो तो आपके सॉफ्टवेयर में क्या फीचर होने चाहिए। दिस इज फर्स्ट टाइम दे हैव इंट्रोड्यूस्ड एंड आई मस्ट से डेफिनेटली दिस इज अ वेरी गुड प्रोविजन। बट इशू क्या है, you know कि many companies in India are small companies, small businessmen, they don't have such knowledge, don't much knowledge of the softwares and the accounts. जनरली काफी कंपनीज क्या करती है, अपने यहाँ अकाउंटेंट्स रखती है, अकाउंटेंट्स एंट्री करते हैं, देन उनको चेंजेस भी करते रहते हैं। अब इशू क्या आएगा, अब ऑडिट ट्रेल होना मैंडेटरी हो गया है, तो फर्स्ट वी हैव टू लर्न, टीच देम, वी हैव टू टीच देम कि अब आपके सॉफ्टवेयर में ये फीचर होना चाहिए। एवरी क्लाइंट, मतलब अगर आप प्रैक्टिस में हो तो आपको अपने एवरी क्लाइंट को समझाना पड़ेगा, यू हैव टू मेक देम अंडरस्टैंड कि देयर शुड बी ऑडिट ट्रेल ऑप्शन इन योर सॉफ्टवेयर। एंड इवन ये भी बताना पड़ेगा इस ऑडिट ट्रेल का यूज किया है कि एक एडिट लॉग बना देगा. सो बेटर टू ट्राई कि आप कोई एंट्रीज नहीं चेंज करो अनटिल अनलेस आपके पास उसको चेंज करने का एक प्रॉपर जस्टिफिकेशन नहीं है. बिकॉज आप जब भी एंट्री में कुछ चेंज करोगे, जब भी एंट्री डिलीट करोगे, एडिट करोगे, तो वहां पे एक प्रॉपर डेट वाइज एडिट लॉग बन जाएगा कि पहले दिन जब एंट्री किस दिन हुई थी, क्या एंट्री हुई थी, जब जब चेंज हुआ उसकी डेट और चेंजेस प्रॉपर मेंशन होंगे. तो दिस इज द फीचर ऑफ द एडिट लॉग. पहले मिनिस्ट्री इस प्रोविजन को 1 अप्रैल 2021 से एप्लीकेबल कर रही थी. देन ऑन द रिक्वेस्ट ऑफ द प्रोफेशनल की इतनी जल्दी विद इन 7 डेज कैसे पॉसिबल है सभी के लिए करना, they have deferred it from the 1st April 2022. But the 1st April 2022 is not far. और ऐसा नहीं होता ना कोई नई चीज आई है पहले दिन से हमें समझ आ जाए. तो दिस इज माय सजेशन, दिस इज माय ओपिनियन कि आपको अभी से अपने क्लाइंट्स को, अपने स्टाफ को, अपने कलीग्स को इस चीज के लिए अवेयर करवाना पड़ेगा. बिकॉज डायरेक्टली अगर 1 अप्रैल को हम ये प्रोविजन डिस्कस करेंगे और डायरेक्टली यूज करेंगे तो हो सकता है बहुत तरह की मिस्टेक्स करें. तो वी हैव टू मेक देम अंडरस्टैंड दिस इज एट राइट नाउ. बिकॉज इन 2 महीनों में वो हो सकता है कि ऑडिट ट्रेल्स को हम इनेबल करके सीखें कि अच्छा कैसा एडिट लॉग बनता है, कैसे ऑडिट ट्रेल बनती है. तो बेटर है कि जो मिस्टेक्स हम 1 अप्रैल के बाद करने वाले हैं, जब वो मैंडेटरी चीज है, वो मिस्टेक्स हम आज ही कर ले. बिकॉज आज की डेट में चीज मैंडेटरी तो नहीं है. एक बार हम सीख जाएंगे तो हम इस ट्रेल को तो डिलीट भी कर सकते हैं, बट उस ट्रेल को हम डिलीट नहीं कर सकते. तो ऑडिट ट्रेल बिकम मैंडेटरी विद इफेक्ट फ्रॉम 1 अप्रैल 2022. किसी का कोई भी क्वेश्चन ऑडिट ट्रेल से रिलेटेड यू कैन आस्क फ्रीली. Because now next provisions पे जाएंगे तो those are not relating to the audit trails. तो इसलिए किसी का कोई भी डाउट हो तो audit trails पे you can ask to me. अब होता है कि मेन क्वेश्चन आता है ऑडिट ट्रेल का बेनिफिट्स क्या है टू प्रिवेंट फ्रॉड. अब क्या है कि जब आप एज अ ऑडिटर ऑडिट करने जाते हो और एज अ ऑडिटर जब आप ऑडिट करते हो तो आपको अगर स्पेसिफिक पूरी अगर ट्रेनिंग मिल जाती है कि कंपनी ने हाँ पहले दिन ये एंट्री की थी, फिर ये चेंज की थी, तो यू कैन आस्क देम सो मेनी क्वेश्चंस कि क्यों चेंज किया, चेंज करने के पीछे जस्टिफिकेशन क्या थी. तो इट विल हेल्प टू प्रिवेंट फ्रॉड. बिकॉज क्या होगा कि सामने वाला प्रॉपर एंट्रीज करेगा, डाटा के साथ छेड़छाड़ नहीं होगी, डाटा में चेंजेस नहीं होंगे. तो फ्रॉड को प्रिवेंट करना वन रीजन. स्ट्रेस फ्री ऑडिट. डेफिनेटली आज की डेट में अगर एज ऑडिटर हम ऑडिट करते हैं तो डोंट नो कि कब क्लाइंट ने क्या डाटा चेंज किया, कब एंट्री चेंज हुई है. बट जब ये ऑडिट ट्रेल इफेक्टिव हो जाएगा तो हम किसी भी क्लाइंट की जब ऑडिट करेंगे एंड देन दैट टाइम वी विल चेक देयर अकाउंटिंग सॉफ्टवेयर, तो हमें पूरा ऑडिट ट्रेल मिल जाएगा कि कब कब क्या क्या उन्होंने चेंजेस किए हैं. तो हमारे पास एक ऑप्शन होगा ना टू आस्क देम कि व्हाई दे हैव मेड देयर चेंजेस, व्हाट इज द जस्टिफिकेशन बेहिंड चेंजेस इज दे मेड. अगर वो कुछ फ्रॉड कर रहे हैं, कुछ इलीगल एक्टिविटीज कर रहे हैं, देन ओनली वी विल कम टू नो कि अच्छा ऐसा कुछ कर रहे हो. इजी एरर करेक्टिंग एंड टाइम सेविंग. और दूसरा क्या है, अब ऑडिट ट्रेल के थ्रू एरर करेक्ट हो रहे हैं, अगर कहीं नहीं हो रहे, कहीं गलत एंट्री है, तो वो एरर्स इजीली यू कैन फाइंड आउट कि ओके ये ऐसे ऐसे चेंज हुआ, इसमें ये चेंज नहीं होना चाहिए था, ये चीज चेंज होनी चाहिए थी. दैट थिंग विल हेल्प यू in the audit also, that will help you to the auditor also. Now I have one question. This is my habit to generally क्या है कि अभी तो सेमिनार्स नहीं हो रहे, वेबिनार्स हो रहे हैं, तो सेमिनार्स में तो क्वेश्चन आंसर्स में काफी मजा आता है. बट यहाँ पे मैं बोलूंगा as I can see 200 persons are joining this webinar, attending this webinar. So let's interact also with each other because जितना हम interact कर सकते हैं उतना हम better understanding ले सकते हैं provisions के लिए. So I have one question for all of you. Whether this amendment, this audit trail amendment is applicable on every company or exemption are given to some class of companies like small company. What is your view on this? कि audit trail सभी के लिए है या कुछ को exemptions है? Anyone have any view? As I can see 200 persons are there, so we can.
Yeah. You can give your view on chat box.
Yes, definitely. Because there should be little interaction also because of webinars ना, जो webinars में बाकी सब चीजें तो बहुत अच्छी है, but this is the only drawback, interaction कम हो जाता है हमारे webinars में. So mostly answer I have received all the companies. So see, this is the thing. यहाँ पे मिनिस्ट्री ने ऐसा कोई प्रोविजन नहीं किया है कि ये सिर्फ पब्लिक कंपनी पे लगेगा या नॉन स्मॉल पे लगेगा. On each and every company this will applicable. Every company which is using the accounting software. तो आज की डेट में ऐसी कंपनी कौन सी होगी जो अकाउंटिंग सॉफ्टवेयर नहीं यूज करती है? एक नील टर्नओवर की कंपनी भी होती है ना, वो भी अपने अकाउंट टैली या सॉफ्टवेयर के थ्रू मेंटेन करती है. सो प्रैक्टिकली वी कैन से कि ऑडिट ट्रेल इज एप्लीकेबल ऑन ईच एंड एवरी कंपनी which is incorporated under Companies Act with effect from the 1st April 2022. The major responsibility on us as an auditor, we have to teach the client, we have to teach it to the accountants of the client, to our colleagues. Everyone should be aware about this. So hope this audit trail is clear to everyone and its applicability is also clear. Now the second amendment in the company's account rules. Second amendment they have made in Rule 8, which is practically relating to the director reports of the companies other than small company and OPC. Small companies and OPC's director reports are not, Rule 8 does not apply on the director report of the small company and OPC. So other than small company and OPC, these new disclosures, new clauses shall also be there in the director report as on 31st March 2022. As it mentioned here, matter to be included in the board report in Rule 8, Sub-Rule 5. After clause 10, 2 new disclosure added. So earlier there was a 10 disclosure as per Rule 8, but now 2 more they have added. Number 1, the detail of the application made or any proceeding pending under insolvency bankruptcy code during the year, along with their status as at the end of the financial year. अगर कंपनी ने कोई आईबीसी में एप्लीकेशन लगाई है और वो एप्लीकेशन लगाई है या उसकी कोई प्रोसीडिंग्स पेंडिंग है, तो उसके रिगार्डिंग आपको डायरेक्टर रिपोर्ट में डिस्क्लोजर देना पड़ेगा. उसका स्टेटस भी एट द एंड ऑफ द ईयर क्या था उसके बारे में भी प्रॉपर डिस्क्लोजर देना पड़ेगा. अभी तक आईबीसी से रिलेटेड कोई डिस्क्लोजर डायरेक्टर रिपोर्ट में नहीं था. हम सभी कंपनीज के लिए डायरेक्टर रिपोर्ट बनाते हैं, बट किसी भी कंपनी में आईबीसी का डिस्क्लोजर नहीं था. This is the first time they are introducing the disclosure about the IBC proceedings and applications in the director report. So now after from this financial year ended 31st March 2022, आप लोगों को अगर आपकी डायरेक्टर्स रिपोर्ट में अगर आपकी कंपनी नॉन स्मॉल है, पहली चीज नॉन स्मॉल होना चाहिए. स्मॉल एंड ओपीसी के ऊपर तो डिस्क्लोजर लगता ही नहीं है, बिकॉज वेरी क्लियर है, यहाँ लिखा है रूल 8 और रूल 8 डज नॉट एप्लीकेबल ऑन द स्मॉल कंपनी. What is the new definition of the small company? Sorry for that, but my session will be full of question answer, because according to me, only these questions are the things which can keep us wake up. Are you aware about the new definition of the small company? Because drastic change हो गया है small company के definition में, और उसका impact बहुत है. मतलब definitely for the chartered accountant, we are a chartered accountant, statutory auditor, we should be aware about that. So anyone can tell me what is the small company as on date? New definition. As per the old definition, someone mentioned turnover 100 crore or net worth 10 crore, okay. Paid up share capital 2 crore and turnover 10 crore, okay. 2 answers I have received. See, 2 out of 200, 2 answers I have received, but these 2 answers are already different. Turnover less than 20 crore, okay. So see, different answers. There is one person has mentioned 2 crore and 20 crore, okay. Earlier, the definition of the small company was a company having paid up share capital up to 50 lakh and turnover up to 2 crore. That means company is a small company. 2 crore or 50 lakh or 2 crore. Okay, one more answer we have received. Turnover less than 20 crore, capital less than 50. Okay, I just give you the answer. As per Companies Act, small company means a company which is having paid up share capital up to 50 lakh, turnover rupees 2 crore. ये definition थी till 31st March 2021. But this year, जो 21-22 का हम बात कर रहे हैं, 21-22 जिसके रिगार्डिंग हम डिस्क्लोजर्स की बात कर रहे हैं, जिसके रिगार्डिंग हम अमेंडमेंट्स की बात कर रहे हैं, the definition of small companies has drastic change with effect from the 1st April 2021. The new definition of the small company means a company having paid up share capital up to 2 crore. Paid up share capital up to 2 crore and turnover up to 20 crore. अगर एक कंपनी दोनों condition, if a company fulfill both the condition, then such company shall be considered as a small company. So first thing, whenever you will prepare the director report, you just have to check whether your company is a small company or not. Because if it is a small company, these disclosures, 2 disclosures which we are going to discuss are not applicable on them. Because these disclosures are applicable on every non-small company. So the first disclosure is relating to the details about the application and the pending proceeding of the IBC. Then next, the details of the difference between the amount of valuation done at the time, one-time settlement, and valuation done while taking loan from the banks or financial institution. If your company have done any one-time settlement with the creditors and all in the ABC, that time what valuation, whatever valuation they have done, और जो valuation वो तब करते हैं जब उन्हें बैंक से financial institution से loan लेना होता है. अगर दोनों valuation में difference है, then company have to justify in their director report what is the reason of this difference. Difference का reason क्या है, difference क्यों है, they have to justify it. Earlier ऐसा provision नहीं था, but now this is the provision because we all must be aware. मैं इन्हीं से regarding जो भी points है वो भी discuss करता रहूँगा. We must be aware Companies Act में अगर हमें valuation करवानी है तो who is eligible to do valuation under Companies Act? Companies Act के किसी भी provision में करवानी है अगर valuation, तो only and only the registered valuer is allowed to do the valuation. Earlier there was a provision chartered accountant having 10-year experience, that provision has been removed. So only the registered valuer can do the valuation. So that's why we have mentioned कि जो भी valuation में difference होगा उसके ऊपर आपको justification देना पड़ेगा. So these will be two new disclosure in the directors report of the companies other than the small companies or other than the OPCs for the financial year 21-22. This question is not relevant right now. Like I mentioned, one more question. As I said, my presentation will be full of questions because my personal understanding is that until unless we don't have to answer a question, हमारा mind उतना open होता नहीं है. So we should discuss the question. That's why I said कि किसी का कोई question हो तो आप लोग भी पूछ सकते हैं. Otherwise, I will keep it tasky. That's why I mentioned this question: whether the amendment applicable to the director's report, these two new disclosures, is applicable on the every company or exemption is given to some class of company. So we are clear now. Exemption is given to the small companies and OPC because Rule 8 does not applicable on the small companies and OPC. Rule 8 is applicable only on the non-small company. Second notification, Audit and Auditor Amendment Rules 2021. First हमने discuss किया accounting amendment in the account chapter. Now amendment in the audit and auditors rules. Amendment in Rule 11. That is other matter to be included in the auditor report. We all prepare the auditor report. At the time of the preparation of the auditor report, we refer the Rule 11 of the audit and auditors rules also. So as per Rule 11, what amendment they have done, I'm just going to tell you. There was a clause D. They are omitting this clause D and adding 3 new clauses E, F और G. So clause D को तो वो लोग remove कर रहे हैं, clause D को तो वो delete कर रहे हैं Companies Act से, और इसके place पे वो लोग add कर रहे हैं clause E, F और G. 3 new clauses has been added. So clause D is replaced by clause E, F और G. D क्या था जो delete हो रहा है वो भी हम discuss कर लेते हैं. As I mentioned here, Rule 11D, where the company has provided requisite disclosure in the financial statement holding of the specified bank note. You must be aware, after demonetization in 2016, Ministry have added a new clause in the director report about the specified bank note. They mentioned that companies have to give disclosure on the specified bank notes. Now this clause will be deleted. Till 31st March 2021 auditor report, you must have mentioned this clause, but now this clause is getting deleted and this clause is not required under the auditor report preparation for the financial year 31st March 2022. So this clause is completely getting omitted. Now 3 new clauses are getting added: E, F, and G. Let's discuss what is E. New clause E. Language is there on your screen. Whether the management has represented that to the best of its knowledge and belief, other than a disclose in the notes to accounts, no fund has been advanced or invested by the company to or in any other person, including foreign entity, with the understanding whether recorded is writing, otherwise that the intermediary shall, whether directly and indirectly invest in other person entity identified in any manner whatsoever by behalf of the company. Means अगर कंपनी ने किसी को लोन दिया है, गारंटी दी है, सिक्योरिटी दी है, like I mentioned here, advance any loan, guarantee and invested anywhere but through any intermediaries. But sometimes what happened, company A is giving fund to company B, but the actual motto is to give loan to the company C, but because of many reasons A are not able to give the company C. So first they will give loan to the company B, A to B, then B will give loan to the company C on the behalf of A. So ultimately beneficiary is C. As I mentioned here, entities identified in any manner whatsoever by behalf of the company or provided any guarantee security like on behalf of a ultimate beneficiary. So generally what happened, A has given loan to B and B has given loan to C on behalf of A. So ultimately beneficiary is C. But many times what happens is these things are not, we can say, described in the balance sheets. Because what our financial statement will show, the company has given the loan or guarantee or security to the B. But ultimately, who is the ultimate beneficiary? Who is the ultimate beneficiary in this transaction? In this transaction, ultimate beneficiary is C, not B. B was just intermediary, as we have used the word here, intermediary. But ultimate beneficiary, who is ultimate beneficiary? Now, this is definitely the responsibility of the auditor to check this type of transaction. If a company is giving loan to anyone directly, indirectly, and invest or lend directly, indirectly anywhere, it is the duty of the auditor to ask from the, we can say, corporates and ask to the client about the ultimate beneficiary. They have to look this transaction. So अभी तक auditor report में ऐसा कोई disclosure नहीं देना पड़ता था. But now, as mentioned there, auditor have to check the details in the notes to account and take a representation from the director about such clause and check all the transactions of the company in respect of loan, advance, investment, their respective documents. Because till now, there was no such reporting responsibility on the auditor about such provision. But after this amendment, now there is a, we can say, now there is responsibility of the auditor of the company to give this disclosure in the auditor report. So now auditor have to find out the ultimate beneficiary. Now auditor have to check who is the intermediary through whom company have routed the transaction, and all those details auditor have to give a proper disclosure in the direct auditor's report. This is clause E is going on. This is clause E part 1 and clause E part 2. Part 1 we have discussed where the company has given the loan and investment. Part B 2 is talking about where company have received the loan or investment. So both sided, vice versa. In the above transaction, we have seen to whom we has given the loan. Now we are seeing to whom, from whom we have received the loan. So both the transaction we have to identify. Like I have mentioned, given some comment. Auditor have to check the notes of account, take mention about the check all the transaction with that loan advance received by the company and their respective documents. So ऐसा नहीं है कि ऑडिटर्स को सिर्फ वही ट्रांजैक्शन चेक करना है जहां कंपनी ने लोन दिया है, गारंटी दी है, सिक्योरिटी दी है किसी इंटरमीडिएट के थ्रू अल्टीमेट बेनिफिशियरी को. इवन वो ट्रांजैक्शंस भी चेक करने हैं जहां पे कंपनी ने लोन लिया है. So both the things have to be checked. Third, based on the such audit procedure that the auditor has considered reasonable and appropriate in this circumstance, nothing has come to their notice has caused them to believe that representation contain any material or misstatement. उन्हें disclosure देना है कि regarding point 1 और 2 के regarding को जो भी disclosure दे रहे हैं वो कोई misstatement नहीं है. That is a proper statement. That is on the basis of the facts whatever they have checked. As mentioned, the reasonable, consider reasonable and appropriate circumstance whatever they have checked. Second point, second disclosure, whether the dividend declared or paid during the year by the company is in compliance with section 123. इस point से मनीष ने क्या किया है? If you will just I will take 2-3 minutes to discuss one thing. If you will go through the disclosure of the auditor report in 1956 Act, and if you compare the disclosure of the 1956 Act with the disclosure of the 2013 Act, you will see one important thing कि मिनिस्ट्री ने क्या क्या है ऑडिटर रिपोर्ट्स में ऐसे चेंजेस किए हैं कि बहुत सारे सेक्शंस की कंप्लायंसेस की बर्डन ऑडिटर्स पे डाल दी है. Like section 185, auditor have to give disclosure की company has complied with 185, 186, section 73. अभी तक डिविडेंड के ऊपर ऐसा नहीं था, डिविडेंड पे डिस्क्लोजर्स तो ऑडिटर्स देते ही थे, बट ये कहीं नहीं था कि ऑडिटर्स ये चीज की रिस्पॉन्सिबिलिटी ले रहा है कि कंपनी ने सेक्शन 123 प्रॉपर कंप्लायंस किया है। 123 सेक्शन कंपनीज एक्ट में है टू डिक्लेयर टू पे डिविडेंड ऑन द डिविडेंड टू द शेयर होल्डर्स, बट नाउ दे हैव एडेड अ क्लॉज, ऑडिटर हैव टू स्पेसिफिकली गिव हिज कमेंट ऑन दिस whether the dividend declared or paid during the year by the company is in compliance with 123। मतलब अब सिर्फ ऑडिटर्स को ये नहीं देखना कि डिविडेंड का क्या स्टेटस है, पे किया नहीं किया, डिक्लेयर किया नहीं किया, ऑडिटर्स को ये भी चेक करना है कि डिविडेंड देने के लिए जो प्रोसेस फॉलो होना था वो प्रॉपर प्रोसेस फॉलो हुआ है कि नहीं, whatever the process was there whether we have followed or not, whatever the compliances was there whether we have the company have done or not. So this is now responsibility of the auditor. Earlier ऐसी कोई responsibility auditors पे नहीं थी. So one thing which I have noticed by all these amendments, चाहे हम CARO के amendment को read करें या Schedule 3 के amendment को read करेंगे या auditor reports के amendment को read करते हैं, एक चीज common है कि ministry is increasing the responsibility of the auditor. जनरली मैं एक चीज बोलता हूँ कि मिनिस्ट्री को वैसे भी डायरेक्टर से ज्यादा ऑडिटर से प्रोफेशनल से प्यार है. So whenever they have to issue the notice along with the company, they always issue the notice to the professional also, because according to the ministry, professional are the mediators between company and them, between company and ministry. So professional should aware about everything. So इसीलिए वो regularly by increasing the compliances, by increasing the disclosures, ऑडिटर्स की रिस्पॉन्सिबिलिटीज इंक्रीज करते जा रहे हैं. सो अभी तक ऑडिटर्स को डिविडेंड डिक्लेरेशन और पेड का प्रोसेस चेक करने की रिक्वायरमेंट नहीं थी फॉर देयर ऑडिट पर्पस, बट अब ऑडिटर्स को प्रॉपर प्रोसेस चेक करना है कि सेक्शन 123 का प्रॉपर प्रोसेस फॉलो हुआ है कि नहीं, 123 के प्रॉपर कंप्लायंसेस हुए हैं कि नहीं, 123 से रिगार्डिंग जो भी पॉइंट थे प्रॉपर कवर हुए हैं या नहीं. तो आई मस्ट से every auditor should be properly now aware about the process and provision of the dividend offer under section 123. Even recently yesterday I have seen कि ICAI ने dividend के ऊपर recent में एक वो भी issue किया है, क्या बोलते हैं, guidance note भी. So I would suggest to everyone to go through those guidance note also जो ICAI ने issue किया है. That guidance note also help you to understand we can say the process, the provisions of the dividend. So how whatever we are discussing till now is clear. फिर एक और पॉइंट हम डिस्कस कर लेते हैं, ऑडिटर रिपोर्ट. जैसा मैंने बोला था ऑडिटर रिपोर्ट में क्लोज डी तो डिलीट हो गया है, क्लोज ई, एफ और जी ऐड हो गए. ई हम डिस्कस कर चुके हैं, एफ एंड जी इज रिलेटिंग टू द ऑडिट ट्रेल. अभी हमने ऊपर ऑडिट ट्रेल डिस्कस किया था कि कंपनीज को ऑडिट ट्रेल वाला ही सॉफ्टवेयर यूज करना है, ऑडिट ट्रेल इज मैंडेटरी. नाउ मिनिस्ट्री पुट द बर्डन आल्सो ऑन द ऑडिटर्स. Every compliance burden is on the auditor. Like if you will read this paragraph, whether the company has used accounting software for maintaining of books of account, which is having a feature of audit trail, and the same has been operated throughout the year for all transactions recorded in the software, and audit trail feature has not been tampered with, and the audit trail has been preserved by the company as per the statutory requirement of record. Now it is the responsibility of the auditors that they have to check whether whatever software the company is using, whether audit trail is there or not. Auditor have to check whether companies maintain the proper audit trail or not. Auditor have to check whether there is any tampered with the audit trail or not. Auditor have to check whether proper edit log is maintained or not. So provisions आया नया कंपनी के लिए, कंप्लायंस आया नया कंपनी के लिए, बट रिस्पॉन्सिबिलिटीज इंक्रीज हो गई है ऑडिटर्स की, बिकॉज अल्टीमेटली दे हैव पुट एवरीथिंग ऑन द ऑडिटर. दैट ऑडिटर इज रिस्पॉन्सिबल फॉर दिस, ऑडिटर शुड बी अवेयर अबाउट दिस. अब आप जब भी अब 1 अप्रैल 2022 के बाद ऑडिट के लिए जाते हैं, चाहे आप मंथली ऑडिट करते हो, क्वार्टरली ऑडिट करते हो, whether you are doing a half yearly audit, you have to check whether audit software is properly maintained or not. You have to check whether proper we can say provisions are using, proper softwares are using, whether there is edit log and everything is maintained or not. So this thing is now important. This thing is important from the point of view of the auditors to understand, because ultimately responsibility is all on the auditors. Responsibility auditors के ऊपर है. They have to report on it. They have to check it. So we all are the auditor. That's why I'm just focusing on this point. हो सकता है कि किसी point पे आपको लगे कि जो मैं discuss कर रहा हूँ बहुत छोटे point है. But sometimes what happen, law में कोई भी चीज छोटी नहीं होती है. Everything have a big impact. So these are the new amendments. We should be aware about this. That's why today I have discussed this. Same question, whether this amendment applicable on the audit report of every company or exemption are given to any company. So practically it is applicable on each and every company. Nowhere exemptions are given to anyone from these three disclosures. So the disclosure number E, disclosure F, disclosure G will be applicable on each and every company, whether it is the OPC, small company, non-small, public, listed, whatever. It is for everyone for financial year ended 31st March 2022. Only one point is there. As audit trail is going to impact from 1st April 2022. So the disclosure G will be applicable for the next year from 31st March 2023. Only the clause G will not be applicable on the 31st March 2022. Okay, someone has asked a question. At the time of audit trail, there was audit trail maintained. But subsequently, after audit is deleted by the client, and what is the responsibility? See, sir, there are the 2-3 points. Practically speaking, you guys are more experienced than me in the audit phase. But 1-2 things which I know, auditor can keep the document with itself while doing audit. So you can keep this audit trail data with yourself. Because you are relying on this data, you are doing audit on because of this data, so you should practically maintain this data with yourself also, or we can say a copy of this data with yourself, because then you will only be able to prove that you have checked everything. Like बहुत सारी ऐसी चीजें होती हैं जब हम audit करते हैं तो we check and we keep the documentation proof with us. So same like that, even you can have a representation letter also. So this thing I think will help us to understand and keep with us. So these are the amendment under auditor's report. Hope it is clear to everyone, because these were the small amendment, but these were also very important amendment. Next is amendment in Schedule 3. This is one of the, we can say, biggest amendment in 2021. If anyone will ask me what is the biggest amendment 2021, I will definitely say the amendment in Schedule 3. Because Schedule 3 already is a big task. शेड्यूल 3 में हमारे बैलेंस शीट आती है, हमारे P&L आते हैं, कैश फ्लो स्टेटमेंट आता है, नोट्स टू अकाउंट्स आते हैं. इतने सारे नोट्स टू अकाउंट्स ऑलरेडी शेड्यूल 3 में बन रहे हैं. नाउ of Schedule 3 they have added more disclosures, more things in the Schedule 3. Okay, someone asked for PDF file, I will definitely share with the chapter and the study circle. So amendment in the Schedule 3 is now also a very big thing. Schedule 3 के बिना तो कोई कंपनी चल ही नहीं सकती है. Practically without Schedule 3, no financial statement can prepare, no financial statement can be done. So Schedule 3 is everywhere. Every year we have to prepare the financial statement in the format of the Schedule 3. Now on with effect from 24th March 2021, Ministry have added the Schedule 3 and they have added new disclosures in the Schedule 3. मतलब delete कुछ नहीं किया है. Generally what happened? They delete, they omit something and they add something, or they substitute something. Now they have not omitted anything, not substituted anything, only added. मतलब disclosures increase ही हुए हैं, कुछ भी कम नहीं हुआ है, कुछ भी replace नहीं हुआ है. And these provisions is effective with effect from 1st April 2021. So now our financial year when will end 31st March 2022. So whatever we are going to discuss in this presentation, all those points should be there in your financial statement. Practically, Schedule 3 is divided into 3 parts. Part number 1, financial statement for a company whose financial statement are required to comply with company's accounting standard rules 2006. Second, financial statement of companies whose financial statement are drawn up in compliance with company's Indian accounting standard rule 2015. सो आप पे अगर अकाउंटिंग स्टैंडर्ड AS एप्लीकेबल होते हैं तो आप डिवीजन 1 के अकॉर्डिंग फाइनेंशियल्स बनाओगे. इफ Ind AS एप्लीकेबल होते हैं तो डिवीजन 2 किसी के अकॉर्डिंग फाइनेंशियल बनाओगे. इफ your company is a non-banking financial company, then you will prepare the financial statement schedule 3 as per division 3. So they have practically divided it into 3 parts: division 1, division 2 and division 3. Division 1 is specifically, we can say, for the AS 2016. Division 2 is Ind AS 2015 and division 3 is specifically for the NBFC companies in compliance with the Ind AS 2015. So now we will discuss all the amendment in the division 1. Now, as same question which we have discussed, what is the reason behind this amendment? Because already financial statement बनाने के लिए इतने disclosures हम देते थे, अब इन disclosures में और क्यों add कर दिया है? Why they came up with the new disclosures now? What is the reason behind that? So see, जब हम reasons की बात करते हैं ना, तो मेरे according to my personal opinion, the biggest reason of the amendment and we can say biggest reason for increase in the disclosure requirement is transparency. क्योंकि जितने ज्यादा disclosures हम बैलेंस शीट पे देंगे, उतने ज्यादा information stakeholder को मिलेगी, उतनी ज्यादा information outsiders को मिलेगी, तो उतनी ही ज्यादा transparency increase होगी. तो major reason behind, we can say, the major reason of this amendment, the major reason for adding of disclosure is transparency. मिनिस्ट्री चाहती है कि ज्यादा से ज्यादा इंफॉर्मेशन आप स्टेक होल्डर को दो, ज्यादा से ज्यादा इंफॉर्मेशन मिनिस्ट्री के पास पहुंचे, ताकि उन्हें एफर्ट्स कम करने पड़े इंफॉर्मेशन को फाइंड आउट करने के लिए. बिकॉज अगर आप ज्यादा डिस्क्लोजर देते तो बहुत सारी चीजें ऐसी होगी कि आप खुद ही ऑन द स्पॉट अपने फाइनेंशियल्स में शो करोगे. तो प्रैक्टिकली व्हाट विल हैपन देयर कि they will have to put less effort to find out the information because we are giving the information on the face. So let's start with the general instructions for the preparation of the financial statement. This is the foremost first amendment on the schedule 3. That is rounding off. As we know कि राउंडिंग ऑफ के लिए अभी तक 31 मार्च 21 तक कोई मैंडेटरी गाइडलाइंस नहीं थी. गाइडलाइंस तो थी बट कोई मैंडेटरी गाइडलाइंस नहीं थी कि राउंडिंग ऑफ मैंडेटरीली इसी गाइडलाइंस के अकॉर्डिंग होगा. तो टिल 31 मार्च 2021 राउंडिंग ऑफ वाज गोइंग एन ऑप्शन. किसी को राउंडिंग ऑफ करना है तो करो, नहीं करना तो नहीं करो. तो राउंडिंग ऑफ वाज वर्किंग ऑप्शनली टिल 31 मार्च 2021. But now rounding off is mandatory. As I mentioned here, for the purpose of rounding off the figure appearing in the financial statement for financial year ended 31st March 2021. So जो financial year 31st March 2021 को end हो रहा है, the total income of the company shall be considered as basis. If total income is less than 100 crore, then round off shall be in the nearest 100, nearest 1000, nearest lakhs, nearest million and near or decimal thereof. And if your turnover, if your total income is more than 100 crore, then rounding off shall be in the lakhs, millions, crore or decimal thereof. So practically अगर आपकी 100 करोड़ तक की टर्नओवर है, 100 करोड़ तक की इनकम है, तो आप 100 में, 1000 में, lakhs में, जो भी नियरेस्ट है राउंडिंग ऑफ कर सकते हो. बट आपकी 100 करोड़ से ज्यादा टर्नओवर है तो आप 100,000 में तो राउंड ऑफ कर ही नहीं सकते हो. If your turnover is more than 100 crore now, then you can round off only in the lakhs, millions, crores or decimal thereof. But you cannot round off in the 100 and 1000 in this situation. So अभी तक जब भी हम बैलेंस शीट बनाते थे 31 मार्च 2021 तक राउंडिंग ऑफ एक ऑप्शनल ऑप्शन था, ऑप्शनल चीज थी. बट अब राउंडिंग ऑफ को उन्होंने मैंडेटरी कर दिया है कि मैंडेटरी राउंडिंग ऑफ सभी के ऊपर एप्लीकेबल हो जाएगी. तो दिस ईयर जब आप अपने अकाउंट्स बनाएं, जब आप अपने फाइनेंशियल स्टेटमेंट बनाएं, तो मेक श्योर कि वो ऐसे ही बनाएं ताकि आपको राउंडिंग ऑफ करने में कोई प्रॉब्लम ना हो, राउंडिंग ऑफ इजीली हो जाए. बिकॉज अगर अपने प्रोविजंस ऐसे बनाए कि राउंडिंग ऑफ करने में प्रॉब्लम आ रही है तो आपको ही वो प्रॉब्लम फेस करनी पड़ेगी. सो ट्राई टू प्रिपेयर द फाइनेंशियल इन सच ए मैनर दैट द राउंडिंग ऑफ विल बी इजी फॉर यू. So now rounding off will be mandatory. This is the first amendment in schedule 3. Next, Additional disclosure in balance sheet. This is the most important provision. This is the provision because of that Borivali chapter has today called me here. However, I have already taken 1 hour to discuss the things, background things, because when जब भी हमने कोई provision discuss करना है, कोई amendment discuss करना है, our background should be clear. Because if our background will be clear ना, it will help us to understand the provision. So बात करते हैं additional disclosure in the notes to the balance sheet. बैलेंस शीट के नोट्स में क्या क्या एडिशनल डिस्क्लोजर्स हमें देने पड़ेंगे जो हम आज तक नहीं देते थे. हाउएवर हम अभी भी बहुत सारे देते थे, बट उन्होंने और बहुत सारे ऐड कर दिए. फर्स्ट इज द शेयर होल्डिंग ऑफ द प्रमोटर. सबसे पहले एक क्वेश्चन मैं आप लोगों से डिस्कस करना चाहूंगा, इवन आप लोगों से पूछना चाहूंगा, व्हाट इज द मीनिंग ऑफ प्रमोटर. अगर कंपनीज एक्ट की बात करते हैं तो प्रमोटर कौन है? हु आर द प्रमोटर्स? एनीवन लेट मी नो. Who are the promoters? Anyone can answer in the chat box. As I can say, more than 200 persons are there, so definitely lot of minds, lot of knowledge is there in this webinar. That is about promoter. अब जनरल कॉन्सेप्ट क्या है, चलो मैं बताता हूँ. Okay, 2 answers I have received. I would love to read that answer. Whose name is appearing under MOA AOA. Okay. Promoters are the initial subscriber to the MOA AOA, first subscriber to the MOA, right? Or person who has formed the company and allotted the shares. So अगर हम बात करते हैं promoters, जनरली जैसे अभी सबने आंसर दिया, प्रमोटर्स कौन होते हैं, सब मोस्टली आंसर्स हमें मिले द सब्सक्राइबर ऑफ द मेमोरेंडम एंड द पर्सन हु इनकॉर्पोरेट द कंपनी. जनरली यही था, जनरली कंपनीज एक्ट में यही होता था 1956. इफ वी विल लुक एट द कंपनीज एक्ट 1956, तो यही डेफिनेशन थी अबाउट द प्रमोटर ऑफ द कंपनी. बिकॉज 1956 में स्पेसिफिकली था ऑडिट, द प्रमोटर ऑफ द कंपनी आर द फर्स्ट सब्सक्राइबर ऑफ द कंपनी. Promoter of the company means a person who has subscribed the memorandum or article of association of the company. तो जनरली अभी तक हमने आज तक यही मीनिंग प्रमोटर्स का डिस्कस किया है, रीड किया है. तो अकॉर्डिंगली वी हैव ऑलवेज गिव द आंसर कि हु आर द प्रमोटर्स ऑफ द कंपनी. बट अगर हम लीगल डेफिनेशन की बात करते हैं, लीगल प्रोविजंस की बात करते हैं कि प्रमोटर्स कौन होते हैं, अगर मैं इस पे आता हूं तो मैं आपको एक छोटा सा प्रोविजन ना अपनी स्क्रीन शेयर करता हूं. जस्ट गिव मी अ सेकंड. लेट मी जस्ट शेयर द स्क्रीन बिकॉज आई वांट टू शो यू द डेफिनेशन, देन आई विल डिस्कस ऑन दैट. Hope the screen is visible. Definition of the promoter is given here in the definition part of the Companies Act. Promoter means a person who has been named as such in the prospectus or is identified by the company in the annual return. Number 1. Or who has control over the affair of the company directly, indirectly, whether a shareholder, director, or in accordance with whose advice, director, instruction, the board of director of Companies Act. So this is the definition of the promoter. अगर आप इस definition को read करते हैं, कहीं भी ऐसा लिखा है था first subscriber या subscriber of the MOA या the person who has incorporated the company? Nowhere it is mentioned. This is just in our mind that promoter means the person who has incorporated the company. Promoter means the person whose name is mentioned on the MOA, but this is totally wrong under Companies Act 2013. Sorry. This is not the concept under 2013 Act. So the definition of the promoter, the picture of the promoter we are having in our mind, that is completely wrong picture. Because of that, I have shown you the screenshot. I have shown you my screen. It was from the MCA website. MCA website itself is saying कि promoter means a person whose name in prospectus or the person who is identified by the company in the annual return. Annual return हम कौन से फॉर्म में फिल करते हैं? Which form we file for the annual return of the companies? Annual return we everywhere we are filing MGT 7 or 7A, right? So see, MGT 7 or 7A is the form for the annual return. So the definition of the promoter is saying, अगर अब मैं बात करता हूँ public और private, definition में लिखा है name the person identified in the prospectus or in the annual return. तो prospectus तो सिर्फ public companies issue करती है. Private company में promoters कौन हो सकते हैं? The person who is identified by the company as mentioned in the annual return. So this year, जब आप shareholding pattern, जो अभी हम एक second, once give me a second. So जो हम इस shareholding pattern की बात कर रहे हैं, this shareholding pattern of promoters, तो पहले pattern बनाने से पहले हमें identify करना पड़ेगा who is promoter. Until unless we will not identify who is our promoter, how we prepare with this. So for that, this year, when you will prepare this shareholding of promoters, first check the annual return of the company to whom they have shown as a promoter. To whomever they have shown the promoter, that person shall be considered as a promoter for this purpose. Because हमें check करना है according to law who is promoter of the company. और वो हम कहाँ से check कर सकते हैं? वो हम check करेंगे from MGT 7. That is annual return of the company. So we have to check the annual return of the company to check who is the promoter of the company. So first we have to identify for MGT 7. Then we have to move forward. Hope the provision of the that is clear about the promoter is clear. So our process, our provision of the promoter should be clear because generally क्या होता है कि हम लोग को वो clarity अगर नहीं होती है ना तो वो चीज हमें एक लेवल पे इशू क्रिएट कर देती है. जैसा कि अगर हम अगर इसी पॉइंट को लेके चलते कि प्रमोटर्स मींस द सब्सक्राइबर ऑफ द एमओए, देन डेफिनेटली हम गलत डिस्क्लोजर दे देते बिकॉज हम उनको लेके ही नहीं चल रहे हैं. डेफिनेशन में तो हम लेके चल रहे हैं जिसका नाम प्रोस्पेक्टस में लिखा है, जिस पर्सन का नाम हमारी एमजीटी 7 में लिखा है. तो अभी हम क्लियर है हु इज प्रमोटर. अब मैं आगे बढ़ता हूँ. द नोट ऑन द शेयर कैपिटल इन द फाइनेंशियल स्टेटमेंट shall mention detail of the shareholding of the promoters along with change if any during the financial year. The format of such disclosure is as follow. It is here. So अब ये disclosures आपको एक नया बनाना पड़ेगा. Every year in the financial statement you have to prepare these disclosures. Or disclosures, what are the column here? Serial number, name of promoters, number of shares held by the promoter, percentage of shares held by the promoter, percentage change during the year. During the year, how many much percent has been changed, that also required to be mentioned. So you have to identify on 1st April how much share that promoter is holding. On 31st March, on how much share that person is holding, and what is the percent of change during the year. So that thing you have to justify here. Hope we are getting clear with the provision, because the only thing I have learned from the webinars or seminars कि हम seminars और webinars पे जितनी भी चीज डिस्कस करें ऐसे डिस्कस करें कि सामने वाले पर्सन को, सुनने वाले पर्सन को क्लियर होना चाहिए. Sometime it may happen कि we are not covering the big thing, lot of things, but whatever small things we are covering, it should be clear. So that's why I'm trying to focus on each and every small part also, so that it will be clear to everyone. So shareholding pattern is now mandatory. Shareholding pattern अभी तक हम जो देते थे, till now we have given the shareholding pattern of the shareholder holding the 5%. Shareholder holding the 5% of the more than 5% of the share capital. So only that shareholding pattern we have given till now. But now we have to give the shareholding pattern of the promoters of the company. And as we know, whenever we have to prepare the financial statement, whenever we have to prepare the notes to account, we have to give the information for this year ended as well as last year ended. So here you have to give the information for the 31st March 2022 as well as for the 31st March 2021. That's why in the starting of this webinar I said कि अगर आपको एक बैलेंस शीट बनाने में 10 आवर्स लगते हैं तो अब आपको एक बैलेंस शीट बनाने में 20 आवर्स स्पेंड करने पड़ेंगे. The time will be double. This year the time will be double. Not only because of new disclosures, the reason you have to give the new disclosure for this year as well as the last year. So double work you have to do. So we have to do double work this year. We have to give the details of the this year as well as the details of the last year here. So shareholding pattern. Here management shall give details separately for each class of share. Yes, this is the point. Now it may happen company have issued different class of share. Equity share, preference share, equity with differential voting right, preference compulsory convertible, preference non-convertible, non-redeemable, different class of share. Some companies issue more than 4 to 5 class of share. So this schedule, this table is required to be prepared for each and every class of shares. This table shall be prepared for each and every class of shares. Whatever doubt, if any doubts came, please ask. Because that doubt will not clear your situation only, that will help to clear the situation of the 200 more persons. So here management shall give details of the separately for each class of share. So this shareholding of the promoter, this shareholding pattern of the promoter shall be prepared for each class of share differently. Next, percentage change shall be computed with respect to the number at the beginning of the year or if issued during the year for the first time, then respect to date of issue. So it may be happen during the starting of the year, the shareholding was different. During the year, company have made the allotment, so accordingly shareholding has been changed. So that thing you have to mention here. So hope the first point is clear to everyone. This is the first disclosure. और मेरे अकॉर्डिंग तो सिर्फ इस डिस्क्लोजर को बनाने के लिए भी हमें बहुत मेहनत करनी पड़ेगी. First we have to identify the promoters. अब क्या होता है? I just tell you a basic thing. Many times companies are also not aware to whom they have shown the promoter. They are on the random basis showing the promoter to anyone, but that's not the thing. They should check to whom they have to show as a promoter. So this thing we have to be very careful. And if maybe they have shown someone as a promoter, but now they don't want to give the shareholding pattern of that person here, then you can suggest to the companies for the 31st March 2022, they can change their promoter in the annual return of 31st March 2022 by passing of a board resolution. So whoever is mentioned under MDD 7 will be your promoter. If this year company have mentioned Mr. A and B as a promoter, next year company is mentioning Mr. C and D, then next year your disclosure will be totally changed. Next year you have to prepare for the C and D. So this is the first new disclosure, that is shareholding pattern of the promoters. Next, trade receivables as in schedule. Okay, one question is here for 31st March 2022. Auditor, we will have to refer MGT 7A file for 2021. Definitely, sir. To whomever you have shown your promoter in the annual return as on 31st March 2021. For them, you have to give the detail in this schedule. One thing, this year Ministry have given the extension for filing of MGT 7. The due date of MGT 7 has been extended up to 28 February 2022. So if any of your client still not filed annual return, so you can suggest them. This is right now also. Just give me a second. Sorry. So right now, the date of the MGT 7 has been extended up to 28 February 2022. Still 1 month is there for filing of annual return. So if any of your clients still has not filed their annual return, you can suggest them this change. You can suggest them, you can discuss with them to whom they want to show the promoter. So accordingly, when you will prepare the financial statement of 31st March 2022, you will show the detail of that person. I must say we are having this seminar on very right time. Very right time we are having this seminar so that we can discuss this point, we can close these points. So you can, if any one of your client has still not filed, you can suggest them to file this and discuss with yourself. Next, trade payable means creditor as-in schedule. Company has for required to provide as-in schedule for the trade payable due to the periodicity. See, generally till date, we were providing the as-in schedule. We were providing that. We were providing the trade payables. Trade payables तो आप आज तक बैलेंस शीट में लिखते हुए आए हो, फिर चाहे 1956 एक्ट था, चाहे 2013 एक्ट था. Always we have mentioned the details of the trade payable, secured, unsecured trade payable. Now that thing has been changed. Now your trade payable as in schedule shall be prepared in this format. It itself is showing your effort is gonna increase in manifold. You have to give the detail of the creditors outstanding less than 1 year, outstanding for period 1 year to 2 year, outstanding for period 2 year to 3 year, outstanding for period more than 3 years. Earlier हम क्या करते थे? Earlier we just give the details of the creditors. We give just details of the trade payable. Now that's the not only thing. You have to give the details of the trade payable less than 1 year, 1 to 2 year, 2 to 3 year, or more than 3 years. So first you have to identify the traders. Then you have to distribute your traders in these 4 categories. And next, MSME creditors, you require to give details different separately. Others separately. Disputed MSME separately. Disputed others separately. Means some exercises. Exercise number 1, first we will prepare the details of the trade payables, details of the creditors. Then we will divide into them 4 parts: less than 1 year, less than 2 year, less than 3 year, more than 3 year. Then we divided those 4 lists into 4 parts: MSMEs separate, others separate, disputed MSME separate, disputed others separate. So 4 lists of the trade payable we have to prepare. Then we will able to mention this data. So this is in totality is the new thing. In totality, they have added something in their financial statement. So इस schedule को देख के, इस table को देख के, I can say कि lot of efforts we have to do now. And one more thing, one very good thing we have done. You must be aware about the MSME 1 form. Every company have to file MSME 1 form within every half year. So every half year, every company is required to file MSME 1 form, giving the details of the MSME vendor to whom they have made payments after 45 days. So once you file that form, because every half year you are filing, before preparation of the financial year, before preparation of the financial statement, 2 times you have filed that form. These details should be matched from there also. So as an auditor, now it is your responsibility when preparing the financial statement, when preparing the schedules to the financial statement, you have to check the MSME 1 form also. You have to check the MSME 1 form. You have to check the transaction with the MSME vendor specifically. So this is the second edition. So every edition is different in its type. मतलब बहुत logically, बहुत we can say after a very thought process, they have added these disclosures. Means now according to these disclosures, अब आप देखो ना, अगर आप transparency कितना बढ़ जाएगा. If trade payable we have to give details like this, तो any stakeholder can identify कि company के कितने creditors है और कितने सालों से pending है. So everyone have to check कि company के कितने creditors है और कितने सालों से pending है. So your auditor, you as an auditor, you can question to them, why you are not paying to the creditors? Why, if you are not paid to this MSME vendor, then we have to make the provision for the interest also. अब issue क्या है? You are preparing the financial statement for the company, and you find out that there are the MSME vendor, company has not made the payment from 1 to 2 years. Then you have to give the disclosure in the balance sheet that company have made default in the payment to the MSME vendor, because you have to follow the MSME Act also, and you have to make the provisions for the interest also. Till now, what happened? जो मेरा basic experience है, maximum time auditors are mentioning in the direct auditors report that company has not made default in the payment of the any MSME vendor, और वहीं पे disclosure close हो जाता था. To regulate that thing, to control that thing, they came up with this provision. Now, just by giving, so now just by giving this information, you cannot say कि difference, you cannot say कि there is no MSME, because अगर आपने यहाँ कहीं भी amount fill कर दिया ना, if single amount भी इन 4 column में से MSME में fill कर दिया, तो आपको MSME एक्ट के अकॉर्डिंग भी बैलेंस शीट्स में डिस्क्लोजर देने पड़ेंगे, आपको इंटरेस्ट भी चार्ज करना पड़ेगा, आपको उसके अकॉर्डिंग कंटीजेंट लायबिलिटीज भी खड़ी करनी पड़ेगी. सो वन थिंग impacting lot of things. So every change, every amendment is special. Next, third, trade receivable aging schedule. Abhi we have just discussed about the trade payable aging schedule. Now here is trade receivable aging schedule. Particular outstanding for following period from the due date of payment less than 6 months. यहाँ पे एक और ऐड कर दिया. यहाँ 4 थे less than 1 year, 1 to 2, 2 to 3, more than 3. Here 5 less than 6 months, 6 months to 1 year, 1 year to 2 year, 2 year to 3 year, more than 3 year. Now here the 5 disclosure we have to give. Earlier there was the 4, now here's the 5, and these are the 5 category. Now the other category. First, undisputed trade receivables considered goods. Undisputed trade receivables considered doubtful. Disputed trade receivables considered goods. Disputed trade receivables considered doubtful. First, you will prepare the schedule. What are the trade receivables? Then divide it into 5 parts: less than 6 months, 6 to 1 year, 1 year to 2 year, 2 year to 3 year, more than 3 year. Then divide into 4 parts: undisputed, disputed, undisputed, doubtful, undisputed, undoubtful, disputed, doubtful, disputed, undoubtful. So lot of working are required now. Earlier we was not giving, earlier secured, earlier we were giving just doubtful, not doubtful, considering good, not considering good, that is okay. But now less than 6 months. Now the thing is that if company का कोई debtor है, example के लिए वो 2 to 3 years category में fall करता है. So auditor can question them why you are not claiming the money from them. Authority can question you that why you are not claiming money for that. Whether you are taking the interest for that. By chance, if you are registered under MSME, then authority will ask you whether you have asked for the interest, whether you have charged the interest. As we know, these days mostly small companies are registered under the MSME. Because whoever is the new client is coming to us for the incorporation of the company, they are getting registered themselves under the MSME also. So maximum small companies are registered under MSME because it is free of cost, they are getting a lot of benefit. So if your company is registered under MSME, your auditor will ask to you why you are not asking the payment. So whether you have asked for the interest, whether you have prepared the provisions for the receivables or the interest. So all those things will impact now. So that's why in the starting I said, most important reason behind all these amendments, most important reason behind adding of this provision was transparency. You yourself can see कि how much transparency they are increasing. अगर इतनी information एक stakeholder को, इतनी information एक shareholder को मिल जाएगी, तो there will be the full transparency, there will be the complete transparency in the provision. So this thing we have to follow. So 3 disclosures we have discussed. Shareholding pattern. Second one, trade payable as in schedule. Third one, trade receivables as in schedule. So 3 disclosures they have added. Let's move to the disclosure number 4. Hope whatever we have discussed till here is clear to everyone. Because as a speaker, it is my responsibility, and this is always a question in my mind कि whatever I'm discussing, it should be clear to everyone. So guys, कोई भी doubt हो तो please feel frankly. Even just one more thing, one point I want to add here. If nothing like you can ask me query in the session also, because we all are the professional. It is our duty to help each other, resolve each other doubt. So if anyone, even after this session also having doubt, you can drop me the WhatsApp message. I may or may not receive the call, but I will definitely revert the WhatsApp message to the at the end of the day. So it's my request for everyone, please clear your points, please clear your doubts. Even मैंने अपने WhatsApp ग्रुप का लिंक भी इसीलिए आपको यहाँ पे दे दिया है कि you can join that link और आप लोग सब अपनी क्वेरीज अगर फ्यूचर में भी हो क्लियर कर सकते हो. आज बोरीवली चैप्टर ने हमें ये अपॉर्चुनिटी दी है टू इंटरेक्ट विद ईच अदर, तो हमें इसका मैक्सिमम यूज करना है. वी कैन आस्क आवर क्वेरीज. 4 disclosure number 4, title deed of immovable property not held in the name of the company. The company shall provide the detail of the immovable property other than the property where the company's leasing and leasing agreement are duly executed. So company shall provide detail of the immovable property whose title deeds are not held in the name of the company in the prescribed format. If such property is jointly held with others, details are required to be given extent to the company share. So sometime it happened, practically this transaction happened less. Further, you guys are more experienced than me to do the audits because मैं audits नहीं करता हूँ practically. So you can see this thing कि बहुत बार ऐसा होता है कि companies having an immovable property, but the title deeds of the property are not in the name of the company. So now companies have to give the disclosures. Now companies have to give the disclosures in their directors in their balance sheet of such immovable properties also. Is for this also they will prescribe the format कि आपको क्या-क्या details देनी है. So this is also a new point. This is also a very important point. This is point number 5, disclosure number 5. Where the company has revalued its property, plant, equipment, PPE, the company shall disclose as to whether the revaluation is based on the valuation of the registered valuer and defined. अब many times we know companies do revaluate. Companies अपनी properties का PPE का revaluation करती है और वो revaluation figure अपनी balance sheet में देती है because उसके according company की worth increase हो जाती है, उसके according company की value increase हो जाती है. तो यहाँ पे उन्होंने specifically पूछा है whether this revaluation is based on the valuation report provided by the registered valuer or not. मतलब they have made it mandatory कि ये आपके लिए mandatory है कि आप यहाँ पे जो भी disclosures दे रहे हो, जो भी आपने अपने plant की, property की, equipment की value में increase किया है, जो भी आपने इनकी value में increase किया है, that should be as per the valuation report of the registered valuer. मतलब registered value के valuation report के according ही होना चाहिए. It's nothing like कि आपने valuation report chartered accountant से ली है, who is not a registered valuer. It's nothing like कि आपने valuation report we can say किसी person से merchant banker से ली है. No, they are not allowed. They are not allowed here. So the only thing you can take the valuation report. You can take the value report, revaluation report on your plant, property, and equipment only from the registered valuer. सिर्फ registered valuer की ही होनी चाहिए. Registered valuer means a person who has cleared the exams of the registered valuer, who is there in the record of the ministry as a registered valuer. So only that person can do that thing. Other person cannot do this. So we have to be very clear on this thing. Please make sure that this thing should be clear, because not only you should be clear, you have to clarify. You have to clarify this to your clients also कि whatever revaluation they are doing should be as per the valuation report. So hope this full disclosure is clear to everyone. One question was there: in case name of the company has changed later, still we need to disclose. So ये name change से regarding disclosures की बात करें, आप किस चीज के please clarify कर दीजिएगा इसे chat box में. Disclosure number 5. This is also very important. Means every disclosure is important, but कुछ होते हैं ना कि जिनमें पूरा कंपनी का बोलते हैं हम, जनरली हम बोलते हैं कच्चा चिट्ठा खोल दिया है. So some disclosure are like this कि you are giving each and every information about the company. You are giving so much of transparency कि anyone can come to know anything. Disclosure shall be made where loans or advance in the nature of loan or are guaranteed to promoters Again, you require to identify the promoters, directors, KMPs, and the related parties as defined under Companies Act, either severally, jointly with any other person, that are repayable on demand without specifying any terms or period of repayment. So see, अगर कंपनी ने किसी को भी लोन दिया है, एडवांस दिया है, लाइक किसी प्रमोटर को, डायरेक्टर को, रिलेटेड पार्टीज को या केएमपीज को, तो उसका भी डिस्क्लोजर देना पड़ेगा. अब यहाँ पे सबसे बड़ा गेम क्या है? What is the biggest thing here? Whether companies are allowed to give loan to director under Companies Act. Whether companies are allowed to give loan to director under Companies Act. What is your stake? Whether companies are allowed to give loan to directors. Section 185. This is the one of the topmost section, one of the topmost important section of the Companies Act 185. I must say every professional, specifically the chartered accountant and company secretary, should be completely aware about the 185 because 185 के बाद 185 के बिना companies work ही नहीं कर सकती. 185 is that much important कि everyone should have a knowledge of 185. Recently, even I have done one workshop on the 185, which is uploaded on my YouTube channel. So whenever any one of you get time, go through that 185 workshop. I must say the provision of 185 will be clear. Even I would suggest these Untitled chapters and their organizers also. Sometimes they can have the session on the 185, 186 plus 188. Those sections are having the big impact on financial statement on the transactions. So I have received 3 answers. That company, no, company cannot give loan to director. Practically, yes, company cannot give loan to director except to WTD or MD. Section 185 subsection 3 stating the some reason, stating the some situations. In those situations, company can give loan to directors, only specific to directors, to MD and WTD. But company cannot give loan to any non-executive director. Any non-executive director or independent director cannot take loan from the company. Only managing director or whole-time director can take loan from the company, except that no one can take. So practically, अगर आपने गलती से company ने दे दिया है, then when they will prepare this disclosure, na, everything will be open. Every non-compliance will be in front of everyone. And see how they have to give the disclosure. Type of borrowers, promoters, directors, KMP, related party. Amount of loan or advance in the nature of loan outstanding. Amount of loan and advance in the nature of loan outstanding they have to give. This is the thing. Percentage to the total loan and advance in the nature of loan. कि कंपनी ने टोटल जितना भी लोन दिया है, फॉर एन एग्जांपल कंपनी ने 100 करोड़ का लोन दिया है और 10 करोड़ प्रमोटर्स को दिया है, तो दे हैव टू मेंशन कि दैट 10% ऑफ द टोटल लोन इज गिवन टू द प्रमोटर्स. मिनिस्ट्री एक्चुअली वांट टू सी अगर कंपनी वर्क कर रही है, कंपनी ने लोन लिया है कहीं से, तो कहां कर. सो एवरीवन शुड बी नो. कंपनी मिनिस्ट्री वांट कि जब आप बैंक के पास जाओ लोन के लिए, किसी स्टेक होल्डर के पास जाओ इन्वेस्टमेंट्स के लिए, तो एवरीवन शुड नो कि हाउ मच लोन कंपनी हैज गिवन एंड हाउ मच लोन इज गिवन टू द प्रमोटर, डायरेक्टर, केएमपी एंड रिलेटेड पार्टीज. सो एवरीथिंग विल बी क्लियर फ्रॉम दिस डिस्क्लोजर. ये डिस्क्लोजर अपने आप में गिविंग अ वेरी क्लियर पिक्चर्स if company is providing loans and guarantees to their shareholders. So this is giving this situation is giving the big relief picture to the everyone. So this was the disclosure number 6. Disclosure number 6 of the, or we can say this disclosure in the schedule 3. Now the disclosure number 17. Disclosure number 7. Detail of the Benami property. Detail of the Benami property held by the company. This is 7 disclosure. In case any proceeding has been initiated, focus on the word. Any proceeding has been initiated or pending against the entity. Any proceeding initiated or pending against the entity under Benami Transaction Act 1988 the corresponding disclosure shall be provided in the financial statement. The company shall disclose the following. अगर कंपनी के अगेंस्ट कोई भी प्रोसीडिंग इनिशिएट होती है ड्यूरिंग द ईयर या कोई भी पुरानी प्रोसीडिंग भी पेंडिंग है अंडर बेनामी ट्रांजैक्शन एक्ट, देन कंपनी को ये सब डिटेल्स अपने डिस्क्लोजर्स में देनी है, नोट्स टू अकाउंट्स में. डिटेल ऑफ द सच प्रॉपर्टी इंक्लूडिंग ईयर ऑफ एक्विजिशन, अमाउंट देयरऑफ, डिटेल ऑफ द बेनिफिशियरीज. If property is in the book, then refer to the item in the balance sheet. If property in the book, refer to the item in the balance sheet. If property is not in the book, then the fact shall be stated with reason. Where there are proceeding against the company under this law as the obtained transaction, nature of the proceeding, status of the same, and company's view on the same. मतलब कहीं भी नहीं छोड़ रहे हैं. Everything they want to get everything about. They want to know everything about the company. कहीं भी वो कंपनी को छोड़ नहीं रहे हैं, कहीं भी वो कोई इंफॉर्मेशन नहीं कर रहे हैं कि आपको एक मौका ही नहीं देना चाहते हैं वो किसी भी प्रोविजन में. So each and everything they want to ask from you. So this is the 7 disclosure of the Benami property held. Now 8th disclosure of borrowings, where the company has borrowing from the banks and financial institution on the basis of the security of the current asset. Generally हमें पता है कि companies बहुत बार we can say बहुत बार companies loan लेती है on the basis of the current asset. Current assets के base पे company बहुत बार loan लेती है. अब क्या होता है कि current assets के base पे loan लेती है ना, उनको कुछ रिटर्न सबमिट करनी पड़ती है, क्वार्टरली रिटर्न्स. ये अभी नया प्रोविजन नहीं है. दिस वाज द अर्लियर प्रोविजन. व्हेन कंपनी टेक लोन फ्रॉम द बैंक, फाइनेंशियल इंस्टीट्यूशन, देन दे सबमिट द करंट एसेट्स रिपोर्ट विद देम. Quarterly report on the current asset status. Now what happened? Specifically mentioned where the company has borrowing from the bank or financial institution on the basis of the security. On the basis of the security, it shall disclose the following. Number 1, whether the quarterly return or the statement of the current asset filed by the company with the banks, financial institution are in the agreement with the books of accounts or not. Generally what happened practically, I'm telling you, practically जब ये disclosure जाती थी ना कंपनी के पास अभी तक, banks और financial institution के पास, तो बुक्स में जनरली बुक से मैच भी नहीं होती थी, ओवरऑल चली जाती थी. बट नाउ व्हाट्स दे आस्क, फर्स्ट यू हैव टू गिव द डिस्क्लोजर whether they are same as mentioned in the books of accounts. Second, if not, summary of the reconciliation and reason of material discrepancy, if any, to be adequately disclosed. अब क्या होता है, ये ऐसा प्रोविजन है जो आज आपने अगर आज डिस्कस किया तो ऐसा नहीं है कि कंपनी को एट द एंड ऑफ द ईयर आप समझा दोगे. नॉट पॉसिबल, बिकॉज रिटर्न्स वाज गोइंग ऑलरेडी. क्वार्टरली रिपोर्ट, 3 क्वार्टर की रिपोर्ट ऑलरेडी जा चुकी है इस ईयर में. अब इशू क्या है, जो कंपनी ने क्वार्टरली रिपोर्ट सबमिट की, द क्वार्टरली रिपोर्ट व्हिच कंपनी हैज सबमिटेड विद द बैंक एंड फाइनेंशियल स्टेटमेंट, इफ देयर इज एनी difference when company in the difference in the report and the reconciliation, then company have to give proper disclosure in their financial statement that what is the reason for such material discrepancies. So as an auditor, this is our duty, this is our responsibility to aware our clients, to aware our we can say companies about this provision, and to tell them कि now with effect from 1st April 2021, whenever you are submitting the quarterly report with the banks or financial institution, make sure that quarterly report is prepared on the basis of the books of account. If at the end of the year there will be any discrepancies, in the reconciliation, then they have to report it in the balance sheet. They have to give the reason for the such discrepancies, proper reason for such discrepancies. For example, you give the reason for the discrepancies and bank go through your balance sheet, then definitely next time no bank will gonna give you the loan. They will say कि you are giving the quarterly report, but you are not giving the quarterly report at your books of accounts. There is a difference between your quarterly reports and your books and accounts. So it's gonna impact the position of the company. It's gonna impact the value of the company. So these things are required. So ये disclosure पहले नहीं थे, पहले इतनी details नहीं मांग रहा था कोई भी. But now they are asking for all these details. Now they are asking you have to give these details, and not only details, you have to give the reasons. If there is any discrepancies, then you have to give the reasons for the same. So this is now important. So hope it is clear to everyone. Hope this provision is clear to everyone. Now 8th disclosure I have discussed. Just give me 1 minute as I have to change my Wi-Fi for some reason. Just give me. Sorry, just there was a little issue in my Wi-Fi. I have changed the Wi-Fi connection.
No problem, sir.
Let me just come back to my presentation. So 8th disclosure we have discussed. That was the details about the borrowings. So these are the 8 disclosures about the amendment in the Schedule 3. Now disclosure number 9, willful defaulter. Where a company is declared willful defaulter by any bank, financial institution or other lender, following details shall be given. You must be aware many times banks declare a person as a willful defaulter. When a person has taken the loan from the bank, financial institution, other lender, to declare the company as a willful defaulter, now they have to give the following details. Date of the declaration as willful defaulter, detail of the amount for which and the nature of default. This also required to be given. अगर आपकी कंपनी एज अ विलफुल डिफॉल्टर डिक्लेयर कर चुका है कोई बैंक या फाइनेंशियल इंस्टीट्यूशन, तो आपको स्पेसिफिकली मेंशन करना पड़ेगा कि आप विलफुल डिफॉल्टर कब बने और क्या रीजन था कि यू हैव डिक्लेयर्ड एज अ विलफुल डिफॉल्टर. दिस इज वन ऑफ द मोस्ट इंपॉर्टेंट पॉइंट. रिलेशनशिप विद स्टॉक ऑफ कंपनी, डिस्क्लोजर नंबर 10. Where the company has any transaction with companies struck off under section 248 of the Companies Act 2013 or section 560, the company shall disclose the following. As you all must be aware, last 4-5 साल में मिनिस्ट्री ने बहुत सारी कंपनीज struck off किया है. Almost 5 to 7 lakh companies has been struck off by the ministry in last 4 to 5 years, right? अब क्या है, कंपनीज तो struck off हो गई है, बट अभी तक उन struck off कंपनीज के रिगार्डिंग कोई इंफॉर्मेशन वी कैन से कोई डिस्क्लोजर हम नहीं देते थे, कोई इंफॉर्मेशन हम नहीं देते थे. तो अब क्या होगा, अब इन स्टॉक ऑफ कंपनीज के रिगार्डिंग डिस्क्लोजर्स देने पड़ेंगे. और कैसे डिस्क्लोजर देने पड़ेंगे? नेम ऑफ द स्टॉक ऑफ कंपनी, स्टॉक ऑफ कंपनी का नेम और उसके साथ रिलेशन, नेचर ऑफ ट्रांजैक्शन विद स्टॉक ऑफ कंपनी. क्या आपने किसी ऐसी कंपनी की, अगर आपकी कंपनी ने किसी ऐसी कंपनी की सिक्योरिटीज में पैसा लगाया था जो स्टॉक ऑफ हो गई है, तो उसकी इन्वेस्टमेंट अगर है सिक्योरिटीज में, तो बैलेंस आउटस्टैंडिंग कितना है और उस कंपनी के साथ रिलेशन क्या है आपकी कंपनी का. कोई रिसीवेबल्स है, पेबल्स है, शेयर हेल्ड बाय स्टॉक ऑफ कंपनी है, कोई आउटस्टैंडिंग है, कोई भी ऐसा ट्रांजेक्शन है ऐसी कंपनी के साथ जो स्टॉक ऑफ हो चुकी है, तो वो ट्रांजेक्शन नेम मेंशन करो, ट्रांजेक्शन मेंशन करो, कितना बैलेंस आउटस्टैंडिंग है वो मेंशन करो, और उस स्टॉक ऑफ कंपनी के साथ आपका क्या रिलेशन है वो मेंशन करो। अब इसके लिए आपको क्या करना पड़ेगा, अगर कंपनी ने फॉर एन एग्जांपल आपकी कंपनी ने 10 कंपनीज के शेयर होल्ड किए हैं, तो उन 10 कंपनीज के मास्टर डाटा में जाके उन 10 फॉर दैट 10 कंपनीज you have to check their master data and you have to check what is their status, because you have to, otherwise you don't have any option. You have to check what is their status, active or non-active. If any company holding your share, just check their status, whether they are active or not, whether they are struck off. Same like to whomever your company have done the transaction from which any amount is outstanding. If no amount is outstanding, you don't require to give any disclosure. But if any amount is outstanding, then you have to give this disclosure. तो आपको हर ऐसी कंपनी जिसमें आपका इन्वेस्टमेंट है, एवरी ऐसी कंपनी जिस कंपनी का आप में इन्वेस्टमेंट है, और एवरी ऐसी कंपनी जिसके साथ कोई ट्रांजैक्शन है, रिसीवेबल्स है, पेबल्स है, उन सभी की डिटेल्स देनी पड़ेगी और रिलेशन भी लिखना पड़ेगा. Because you know, now stock of companies are mostly of the shell companies. So from this disclosure, ministry want to catch those shell companies, catch those fraud transaction of every company. So now all these disclosures you have to give. So अभी हमने 10 disclosure discuss किए, 10 disclosures को discuss करके you must be thinking कि how many time your work is gonna increase, how many time your efforts are gonna increase. Practically companies are, you know, companies don't increase the fees, but our efforts are getting increased because all of this. Next, 11, registration of charge or satisfaction with the registrar of companies. Where any charge or satisfaction yet to be registered with the registrar of companies beyond the statutory period, detail and reason thereof. As we know, charge creation and modification should be filed with the ROC within 30 days of the creation or modification. In case company fails to file the same, in case company don't file any charge creation or modification till end of the financial year, then company have to give the details of the same in their financial statements. Company have to give the detail, the reasons of the same, why they have not filed on the time. So अब आपको charges के sections पे भी follow करना पड़ेगा, charges पे भी follow checks रखने पड़ेंगे. Compliance with number of layer of companies. 12. Where the company has not complied with number of layer under clause 87(2) of the Act, the name and scene of the company beyond the specified layer and relationship extent of the holding company's downstream company shall be disclosed. As we know, as per Companies Act, a company cannot invest in more than 2 layers of subsidiaries. Means A की subsidiary B, B की subsidiary C, C की subsidiary D. So C की subsidiary D is not allowed. Company can invest maximum up to 2 layers of subsidiary, A की B, B की C. However, same level पे हो सकती है, A की subsidiary B, C, D, E, F कितनी भी हो सकती है. But when we go on the layer wise layer, so a company can have maximum 2 layers of subsidiaries. If any case company have more than 2 layers of subsidiaries, then the name, scene of such company, relationship, and extent of holding in such company is required to be disclosed. So as an auditor आपको check करना पड़ेगा, अगर company की कोई subsidiary है, then you have to check कि उसकी कोई subsidiary है क्या, then you have to check उसकी कोई subsidiary है क्या. So this is the responsibility of the auditors. You have to check this because responsibility of auditor पे इसलिए है क्योंकि audit report में हम सबको certify करते हैं. Now I have to increase the speed. Just one thing I want to say to the host that you know there is a lockdown in Delhi at 8 o'clock. So 8 o'clock I have to leave this session. So I will take just 5 more minutes to discuss the disclosures. Then last 5 minutes we will have to discuss the question answer.
No issues. No issues.
Disclosure of ratios. The amendment requires the companies covered under division 1, 2, 3 to disclose the following ratio. Now all these ratios you have to give in your financial statement. Current ratio, debt equity ratio, debt service ratio, reserve of ratio. So means you have to do the calculation for each ratio. This is now mandatory. पहले ऐसा कभी नहीं था, but now you have to work on each and every ratio. Each and every ratio you have to give. So this will also gonna increase your efforts you're working. And one more thing, the company shall explain the item including the numerator and denominator for computing the above ratio. न्यूमरेटर भी देना है, डिनोमिनेटर भी देना है. एंड एक्सप्लेन shall be provided in case ratio is more changed by more than 25%. For example, debt equity ratio starting of the year आपका debt equity ratio था 10, end of the year आपका debt equity ratio हो गया 13, means it changed by more than 25%. Then you have to give the explanation on the same also. So कितना ट्रांसपेरेंट कर देंगे बैलेंस शीट्स को कि सब चीजें एक बैलेंस शीट में मिल जाएगा और ऑडिटर्स के एफर्ट बहुत बढ़ जाएंगे. Detail in respect of utilization of borrowed fund and share premium shall be provided. If company has borrowed fund during the year or company is having any share premium account, तो उनका कहां पे यूटिलाइज हुआ उसकी प्रॉपर डिटेल्स भी आपको यहाँ पे मेंशन करनी पड़ेगी. Compliance with approval scheme, अगर company is having any scheme of arrangement, mergers, तो उनके रिगार्डिंग आपको disclosures देने पड़ेंगे. This was the 15th disclosure under balance sheet. Now I will take 2 to 3 minutes. Disclosure in the P&L account. Undisclosed income. Many times it happened at the time of reconciliation you find some undisclosed income. Like the company shall give detail of any transaction not recorded in the books of account that has been surrendered, disclosed income during the year the tax assessment. Sometimes क्या होता है कि हमने कोई income disclose नहीं किया but during the assessments या surrender के time हम वो disclose करते हैं. Then company have to give the disclosure in the notes to accounts whether the previous unrecorded income and related asset have been properly recorded. मतलब अगर कोई भी undisclosed income during the year निकलती है because of the surrender, because of the income tax assessment or any other reason, वो आप लोग बता सकते हैं और कौन से reasons हो सकते हैं. That disclaimer on that undisclosed income also required to give under the P&L notes to accounts. CSR disclosure, अगर आपकी कंपनी पे CSR लगता है then आपको notes to accounts में इतनी डिटेल्स देनी है. ऑलरेडी सीएसआर के लिए डायरेक्टर रिपोर्ट का नेक्स्टर बना रहे हैं, ऑलरेडी सीएसआर की मीटिंग्स कर रहे हैं, उसके अलावा भी सीएसआर के लिए इतनी इंफॉर्मेशन देनी है. अमाउंट रिक्वायर्ड टू बी स्पेंड ड्यूरिंग द ईयर, अमाउंट एक्चुअली स्पेंड, shortfall, total previous year shortfall, reason for shortfall, nature of CSR activity. So many things you have to give in your notes to accounts line. Detail of the cryptocurrency and virtual currency. If your company has dealt in has deal or has worked with the cryptocurrency and virtual currency, तो उनकी भी डिटेल आपको अपने notes to accounts में properly details में देनी है. So these all things you have to give in your notes to accounts. So these are the brief about the amendment under Schedule 3, amendment in Director's Report, Auditor's Report. Now there are the 4 to 5 questions in the question answer session. First I will take those questions. Meantime किसी के और भी question है तो you can ask to me. I will try to take 5 to 10 minutes. First question: even though nil amount payable to any creditor, still company has to file half yearly return. If company has not made default of any creditor who is MSME registered, and company ने किसी भी creditors की जो MSME पे registered है उनकी payment में 45 days से ज़्यादा का delay नहीं किया है, तो nil के केस में MSME 1 form नहीं file होगा. Next, revaluation during the year or earlier year. जो भी हम disclosures की बात कर रहे हैं ना, हम during the year की बात कर रहे हैं, because financial statement prepare for the period of the financial year, 1st April to 31st March. So during the year, if you have done any revaluation, then for that you have to give the disclosure. It is from the registered valuer only. Can give salary to advance to the director. Salary advance is allowed up to 1 month salary. Up to 1 month, yes, as per one section deposit definition. Can you give brief about the Benami transaction? The Benami transaction, I think it's required a complete big time to discuss. So we can have any other in any other sessions. And कुछ questions यहाँ पे chat box में भी एक दो है, मैं ले लेता हूँ. Sir, wanted to confirm whether this disclosure provision are applicable to LLP? No, these are specifically amendment under Companies Act. जो Companies Act के amendment है वो Companies Act पे applicable होंगे. Companies Act की कोई भी amendment LLP पे applicable नहीं होगा. So make sure जो भी amendment यहाँ पे हम discuss कर रहे हैं ये सिर्फ Companies Act के लिए थे और ये companies के लिए थे. Okay, someone mentioned if title deeds पे कंपनी का नेम चेंज हो जाता है कि वो भी डिस्क्लोजर्स देना है. कंपनी का नेम चेंज हो गया, अगर आपने टाइटल डीड कंपनी के नाम पे करवा ली, दैट्स ओके. अगर वो कंपनी के नाम पे नहीं है, पुराने नेम पे है, तो इस प्रोविजन को वो कहीं हिट नहीं करेगा, बिकॉज इस प्रोविजन का इंटेंट वो नहीं है कि नेम चेंज हो गया हो. सो होप whatever we have discussed today is clear to everyone, because lot of things was there. I tried to cover each and every point of the Schedule 3 amendment. और अभी टाइम ही ऐसा चल रहा है, जनवरी लास्ट, सिर्फ 2 महीने बचे हैं, उसके बाद तो नेक्स्ट ईयर के जब हम फाइनेंशियल्स पे वर्किंग स्टार्ट कर देंगे, अकाउंट्स पे वर्किंग स्टार्ट कर देंगे, तब हमें डेफिनेटली ऑल स्टार्ट करना पड़ेगा कि ऑन दिस वर्किंग ऑन दिस वी कैन से फाइनेंशियल स्टेटमेंट्स. एंड वन मोर थिंग, जैसा मैंने पहले भी बोला था, किसी को कोई भी क्वेरी आफ्टर द सेशन भी होना, बिकॉज नाउ देयर इज अ लिटिल टाइम शॉर्टेज, बिकॉज 8 o'clock इज द लॉकडाउन टाइम, सो आई हैव टू लीव द ऑफिस. तो किसी को बाद में भी क्वेरीज हो तो मेरा व्हाट्सएप ग्रुप का लिंक भी मैंने दिया है, ये प्रोफेशनल्स के लिए ग्रुप पे आप ज्वाइन कर सकते हो और क्वेश्चंस पूछ सकते हैं एनी टाइम. वन क्वेश्चन इज आल्सो देयर, हाउ टू आइडेंटिफाई स्टक ऑफ कंपनी. जस्ट यू हैव टू, इफ यू आर हैविंग द नेम ऑफ द कंपनी, आप एमसी की साइट पे जाके जब उसका स्टेटस चेक करेंगे मास्टर डाटा में, you will come to know whether company is stuck off or active company. Because इसके अलावा आपके पास एज ऑडिटर या एज ए कंपनी कोई ऑप्शन नहीं है. हमें किसी भी कंपनी का चेक करना है कि स्टेटस क्या है, तो एमसी की साइट से ही हम चेक कर सकते हैं whether a company is a stuck off company or active company. So now it is on you, sir. Sure, sir.
Thank you very much, Mr. Divesh, for a nice, lucid and detailed presentation on the subject. Though you are a company secretary, you have covered everything from chartered accountant perspective as an auditor. Thanks a lot. And I'm really thankful for this presentation, and it will definitely help all the members to prepare a detailed checklist on the basis of which they should conduct the statutory audit for this financial year. Now, since there is a short of time, I'll straight away request our members, Rehans Deria, to propose a well-deserved vote of thanks to you. Thank you very much.
Thank you.
Thank you, Sharad sir. It will be my privilege. Dear members, MCA, through its various amendments, has added various disclosure requirements to make reporting of financial statements more robust and also more transparent. And some of these amendments will bring draconian changes in the way we do audit and the way financial statements are reported. All these changes will be effective for the financial statements ending 31st March 2022. Today, our learned speaker, CS DIVESH GOYAL, has explained and summarized such changes and amendments in the Companies Act very well with the help of various illustrations and examples. He has kept the entire session very interactive and interesting. It will help all of us to prepare ourselves and embrace these changes easily. With this, on behalf of entire BCSE family, I take this opportunity to propose a well-deserved vote of thanks to CS DIVESH GOYAL. Sir, we express our gratitude for joining us and enlightening us on the topic. Thank you. Now I request Sharad sir to take this session ahead.
Thanks a lot. And as Mr. Divesh has informed, you can send, he has already shared his WhatsApp group detailed link also. So whosoever has got any question, he can post it there. Thanks a lot, Mr. Divesh, once again.
Thank you so much, sir.
Good night. Good night, everyone.
Thank you so much.
Thank you.
Nilesh, you want to say something? You are on mute.
Please.
Nilesh, we are not getting your voice. Seems there's some issue with the system. Nilesh, we are not getting your voice, Nilesh. Nilesh, you can just put in a chat box whatever you want to say.
Some technical problem is that.
Some technical, yeah.
No issue, Nilesh. It was a great opportunity, and I think all the members privileged and all the members was happy. Will be happy with this session.
Thanks a lot.
Thank you.
And good night, everyone.
I'm terminating the session. Thank you.
Take care.